And so a direct consequence of the end of Reconstruction was the development of the South and the use of the law to enforce segregation, where you have local police forces, enforcing separate but equal doctrine under Plessy v. Ferguson. And that kind of connects to a brief time period in American history where the Constitution was interpreted by the Supreme Court to recognize that essentially we were developing a racist white supremacy police state. And the Warren Court is probably the most significant period of United States Supreme Court case law history, in the sense that it continued the process for incorporating the Bill of Rights and other constitutional protections for people against state actors, in the sense of particularly southern states, but also any state. But so we have, most significantly, Brown v. Board of Education overturning Plessy v. Ferguson and creating the framework for ending the legal segregation, de jure segregation in the South. And then within that context, you have a lot of cases that largely came out of the South involving police incursions on individual liberties, and acknowledging that states had developed police forces that were obtaining confessions through coercive means, physically attacking people, denying them access to water, and basically torturing people to obtain confessions. You weren't able to have a lawyer unless you could afford one, and only unless it was the most serious cases. And so if you look down through this list of cases, basically the idea and concepts that we have as it relates to constitutional protections against police power were basically initiated through the Warren Court era. And so the right to transcripts for appeals, Griffin v. Illinois. Trope v. Dulles, the establishment of this concept of the evolving standards of decency in the Eighth Amendment. Dusky involved standards for whether or not you're competent to stand trial in a criminal case. Mack v. Ohio established the exclusionary rule in issues of search and seizure under the Fourth Amendment. And really with the Mapp case and Wong-Sun, you have a remedy in criminal cases for violation of your Fourth Amendment rights. Prior to that, the history of case law of Fourth Amendment remedies was civil. And that relates to, again, this concept of prior to the expansion of the police to enforce the segregation goals and other economic goals involving terrorists, is that during the late 1890s, when you have the expansion of the United States economic power and the development of tariffs and economic protectionism, it created an incentive for the federal government to expand its police force so that it could enforce these tariffs. In order to enforce the tariffs, you needed to have a professional police force, because prior to that, a large component of policing was related to individual harms. And so if Andrew assaulted me and I wanted to proceed with assault charges or bring him to a court of law, I would be individually wronged by that. I would have an incentive to then go find a constable and one of the people who are part of the smaller police force, explain what kind of harm had been done to me, seek an arrest warrant, and that I would be responsible for carrying out on the individual who conducted the harm. And so I would go get a constable, fill out my affidavit for an arrest warrant, get it signed by a magistrate, and then the constable would assist me in making the arrest, and we would go to a court of law to litigate that issue, and I would be personally liable for that. So if I made a misrepresentation and I just was looking to get Andrew strung up on false charges, and he was able to defend against that, then I would be civilly liable for the Fourth Amendment violation for his arrest that occurred. And so there wasn't very much of an incentive for police forces to violate individual rights, because the victims of those rights were largely responsible for initiating those proceedings. With the development of economic protectionism and tariffs, no one is going to report a failure to pay a tax. It led to the development of what the modern whistleblower statute, pro-qui-tam statute, where the theory was it takes a thief to catch a thief, and so it encouraged monetary rewards for people who turned in people who weren't paying tariffs and taxes, which is the basis for modern whistleblower laws. But that wasn't enough, and so we needed the development of a largely federal police force too, and also the enforcement of local police forces to promote the economic interests of the country and of the elites who are responsible for passing these tariff laws. And it also relates to the development of machine politics in the North with industrialization and the power of people who own these major mills and productions to hire and create a professional police force to push those interests.
Yes.
I think it's interesting that you can attack a piece of property and then be owned by it later. So like you could end up in prison and they own you. Yeah. You could literally attack property and it will own you. That's interesting here.
And so, I mean, and that's what the National Lawyers Guild is all about, is about recognizing the interest of human rights above the interest of property rights, and having this discourse to understand the extent to which property interests have developed their notions for the law and where they came from, so we can use the law and social movements to make change where we're moving forward from a society that is preserving power of the elites to regaining it and claiming it for the people. Unfortunately, that's not the trend we're going. Since the end of the Warren Court, if you look at pretty much every era of United States Supreme Court case law after that, the Berger Court, the Rehnquist Court, and now the Roberts Court, you see limitations on these major seminal cases that were designed to protect individual liberty interests. And so when you talk about in the context of judicial activism, I think it's important to note that the most judicially active justices are conservative ones that are looking to chip away at these protections that were established in a very small time period of United States Supreme Court jurisprudence. And also too, I mean, you can't really see the numbers here, but the number of agencies and the number of people employed by police agencies has skyrocketed since the turn of the 20th century. The FBI was started, in essence, after the McKinley assassination in 1908. That's when the FBI was started, because what was projected as the threat of anarchists. But it really wasn't the threat of anarchists that led to the development of the FBI. It was the threat of unionization and labor movements moving towards an equal society. And so, and that persisted until, in the 1929 and 1974, you had J. Edgar Hoover really advocating for the development of a professional federal police force, and the arguments were related to mafia issues and prohibition enforcement, and then later on to anti-terrorism efforts through the anti-war movement and monitoring peace activists and labor activists. So we basically have seen from the late 1800s a very, very small number of professional police forces to the development of the modern police force in the 1880s, 1890s, and the explosion of federal police agencies and local police agencies, which coordinates with federal money being spent on local police forcing. So we see militarization across every aspect of law enforcement. It's particularly pertinent for us in Arizona to discuss the militarization of the border. There's a constitutional exception zone to the Fourth Amendment within 100 miles of the border, which provides that you have less Fourth Amendment protections within that 100-mile zone because of the supposed national security interest for law enforcement at the border zone. And when you look at the militarization of the border, it's telling that the statistics for the number of people employed on the border, the amount of fencing on the border, and the amount of money spent on militarization of the border aligns with the passing of NAFTA. And so again, we see an economic interest designed to really frustrate economic freedom of people from Mexico, coordinating with this militarization of the border. Then we have the existence of the modern police state that we see all the time. It's a big discussion right now with the order out of the federal district court for Apple to unencrypt the phones for the San Bernardino shooter. And again, the concern is whose interests are we pursuing with allowing simultaneously the state to engage in massive surveillance, and then at the same time arguing that individuals have to have the autonomy in their communications. And when you look at the explosion of the mass incarceration era, it aligns directly with the war on drugs, which is an effort to, again, promote systems of white supremacy by engaging in over-criminalization in largely communities of people of color to to again, pursue the goals of white supremacy.
And you hear the term high crime area being thrown around in courts sometimes, and anyone with a little bit of common sense can say what that's code for. You know, your high crime area is your predominantly minority communities, predominantly poor. I mean, even though there's just as many, if not more, drugs in Beverly Hills, they're not going to call it a high crime area. You know, that's reserved for the poor.
And you can see it in this concept of broken windows policing, where you focus on these vandalism, on these loitering, things like this, and you say that you fix all this and it'll make the community better. Well, the outcome is that you go into these communities and it just starts targeting more and more and more people. Like, first you get the people loitering on a street corner. Well, then you find the person loitering on their own porch. You've been seeing this in Ferguson and places like this. You start giving them tickets, then you start arresting them for not paying those tickets. It's just like an endless cycle that's just getting worse and worse, frankly.
And so a couple of days ago, there was a discussion at the Morrison Institute, the ASU's Cronkite School of Journalism, about prosecutorial discretion and the changes and the shift of power from the judiciary to the executive branch in the enforcement of the law. And we had a couple state legislators there, senators speaking in the second portion of that panel. And one of them said, you know, that acknowledged that, you know, the war on crime is always very popular, but he didn't really acknowledge with who. And the same with the prosecutor. Sheila Polk from Yavapai County was talking about what the people want, but she wasn't talking about which people. And then there was a limited discussion on the disenfranchisement of felons and how that relates to the disenfranchisement of people of color, particularly African American communities. But there wasn't really any genuine acknowledgement that whenever we're discussing what the people want, when we're talking about pursuing the war on crime and being tough on crime, we're talking about white middle class people. That's what we're talking about, because those are the constituents of the people that are electing these people to pass these laws. And one of the senators challenged the people in the room to name one law you would take off the books. And I was like, well, how about marijuana laws? But, you know, that wasn't really openly acknowledged or discussed. And we have Sheila Polk using public monies to campaign disingenuously about the dangers of marijuana while we're still using this to incarcerate lots of people. We talk about you know, this concept of high crime areas. It's not a high crime area unless you have lots of police and communities targeting those people to arrest them for things that white people don't get arrested for. And so the rate of drug use amongst demographics is higher amongst white middle class people than probably any other demographic, but the arrest rates are lower. And so when we're talking about high crime communities, what we're talking about is highly targeted communities by law enforcement to perpetuate this goal of carrying out a system designed to further the interests of white supremacy. And we act like we're in a post-racial society, and it's simply not true, and this is evidenced by the statistical mass incarceration.